Good evening, everyone. My name is Nitin Nainani, and I'm the president for Cornell Law School's chapter. I'll be the host for this week's FEDSOC Study Break on criminal justice. Before I introduce this week's expert, I do want to clarify that this really is an opportunity for the audience members to ask questions. To that effect, you can do so through Zoom's Q&A function or the raise hand function, and I'll call on you. Now, without further ado, I am honored to welcome Professor Joshua Kleinfeld. Professor Kleinfeld is a professor of law and philosophy at Northwestern University. His work focuses on the theory and practice of criminal law and on the theory and legal foundations of democratic government. As a scholar, he has written widely cited work in the Harvard Law Review, Stanford Law Review, University of Chicago Law Review, and elsewhere, including Two Cultures of Criminal Punishment, Manifesto of Democratic Criminal Justice, and a criminal law based on harm alone, the story of California criminal justice reform. As a public intellectual, he has spoken and written on a wide range of topics tied to democratic values, including a TED Talk on democracy and the pandemic. As a former practicing lawyer, he has represented both major corporations accused of billion-dollar wrongdoing and on a pro bono basis, children accused of homicide. He holds a JD in law from Yale Law School, a PhD in philosophy from Goethe University of Frankfurt, and a BA in philosophy from Yale College. Professor Kleinfeld, the floor is yours.
Hi, Nitin. Hi. Welcome, Land of FEDSOC. It's great to meet you all very virtually, to reach out to you. I understand this is a study break and we're supposed to be having fun, so I'll try not to talk too long, but it's great to connect with all of you.
So I think for a first question, Professor, to get the ball rolling tonight, I do want to ask you, criminal justice reform is a hot topic in American law schools today, but most of what we hear are very kind of left-wing perspectives on the subject. What is a conservative libertarian take on criminal justice reform?
Well, I think we can acknowledge that something has gone badly wrong in American criminal justice. We can acknowledge as conservatives and libertarians, just as heterodox thinkers or free thinkers, that we're punishing far too many people far too harshly, without falling into the various aspects of the left-wing critique that we should not share and that are false or imbalanced. So here are some aspects of the left-wing view of criminal justice reform that I don't share and I don't think we should share. One is the minimization of crime. It's like a denialism that has taken over the criminal justice reform perspective on the left, denying that public safety matters, denying the seriousness of crime to society and to its victims, denying the moral character of criminal wrongdoing. You can't even call it wrongdoing, something other than wrongdoing. Denying the very concept sometimes of personal responsibility. And of course, it's a selective denialism. If there are crimes where women or other preferred groups are characteristically the victims, then you have not denialism, you have a totally unconstrained commitment to blame and punishment. Thought crimes on campus, it's a criminal response. It's a totally unconstrained blame and punishment. So both the denialism and the selective denialism seems to me like errors on the left. Another thing that I think is an error, sensitive as it is to say, is the illusion that criminal system is just a tool for the oppression of Black Americans and other minorities. This Manichaean view where there's bad and good, evil and good. Evil is the Republican Party and the American voter, and criminal punishment is just a tool of oppression. That's just factually inaccurate. And any sort of story that simplistic is probably wrong. And finally, there's the utopianism. There's the obsession with abolition, with defunding, which just imagines away basic facts of human life. I'm reminded of a long tradition on the left of this kind of utopianism. You see it in the Marxist tradition, imagining away basic facts about human self-interest, stakes in their own welfare and their own children, that made the collectivism of Marxist imaginings totally unworkable. There's a great line about Marxism by E.O. Wilson, who is a scientist, an entomologist. He studied ants. And paraphrasing him slightly, he said, "Great theory, wrong species." He thought Marxism was a great theory for ants, but not for humans. So how do you fight back against this? One is with empirics. The reality is America has both a problem of too much punishment, but also a problem of too much crime. We have high crime and excessive punishment. And when we think about criminal justice reform, we just have to keep both in view. We have to address punishment in ways that also address crime. And the only durable version of criminal justice reform has to do both. I think clarity is another tool of pushback. When you hear utopian thinking, you call it by its name. You call it utopianism. When you hear Manichaean theory, you call it by its name, simplistic, moralized Manichaean theory, thinking. Now, race is really sensitive, but I think that we need to find ways to talk about differences in rates of criminal offending and how it's going to hurt, not help minorities to just deny them. And we need to beware of the Manichaean story and the self-flattery of that story. There is a problem of racism. The problem is, how did racism create conditions that led to such differences in crime rates? And we need to fix those underlying conditions that led to differences in crime rates. So I think what we need to build in its place is a realistic version of criminal justice reform. I think I'll leave it there. I have a lot to say on this, but I don't want to talk forever.
Sure. And we do have a question from one of the audience members, Dominique. Thank you for your question. And as a reminder, you all can either raise your hand or you can leave it in the chat. Either is fine with me. So his question is, should criminal justice reform, for example, decreasing the harshness of criminal punishment, be a priority for conservatives at a moment in our time when crime is on the rise and attacks on police pervade our media and culture?
Yes, it should be a priority, but it's got to be the both and approach I was referring to before. We've got to find ways to engage in criminal justice reform while trying to reduce crime. And the two are not mutually exclusive. It's not like you choose between more harshness and less harshness. If that's the choice, then less harshness could lead to more crime, and this isn't the time. But that isn't the choice. There are ways of making criminal justice less alienating and more sensible, more in the hands of local communities who are bearing both the costs of crime and punishment, and empowering those communities to respond to crime in ways that will tend to reduce the crime rate and reduce the harshness of the system.
Great. We have a question from Josiah Rutledge. Does overcriminalization contribute to the minimalization of crime that you mentioned? When ticky-tack offenses are lumped into the same bucket as heinous offenses, doesn't that give the appearance of watering down the whole bucket?
I think that's exactly right and very insightful. I would also say that it tends to reduce our sense that the law is something important and worthy of our respect, when the law doesn't reflect our norms at all. You know, think about that that blue or red FBI warning that you see before every movie that you watch. What does it say? It says any public viewing of this is a 5-year felony. So presumably if you showed it 4 times to groups of friends, you could face a 20-year sentence. Well, that's so outrageous given our norms of justice that it tends to reduce our respect for the law. Or like outside my office, I have an office here in Chicago. I'm on the lake. Those of you who know Chicago know that along the entire length of the lake is Lakeshore Drive. And Lakeshore Drive is an 8-lane divided highway that's one of the main north-south arteries of Chicago. Naturally, on an 8-lane divided highway, people drive 60, 65, and it's reasonable to drive 60, 65. The demarcated speed limit along the entire length of that road is about 40 miles an hour, which means everyone is not just speeding in the sense of a violation of traffic law, they're committing misdemeanors. When you have law like that, it tends to reduce respect for the law. So what part of the project here is to bring substantive criminal law more in line with existing social norms, to see the positive law as a handmaiden to our social norms.
Great. I guess the next question I have for you then is, what do you think about plea bargaining and the trial penalty?
Yeah, so let's quickly clarify. The trial penalty is the idea that if a prosecutor offers a defendant a deal, it's essentially confess and you'll get a break on your sentence. That's what a plea bargain fundamentally is breaks on sentences in exchange for confessions. And in order to effectuate that, you need to have leverage. So you need to say, if you don't confess, you're going to get a very high punishment. We're going to maximize your punishment. So you need to have a trial penalty. That's the excess punishment you get for insisting on your right to trial. I think it's an emblem of a bureaucratized system of criminal justice that is part of what has created this punishment machine that leads to mass incarceration. So imagine that you're all students in my class and I propose a deal. You don't like to take exams and I don't like to grade them. So how about this as a deal? You save me the trouble and expense of grading you and I'll guarantee all of you an A-. What's wrong with that? Well, the answer is it's a betrayal of the basic commitments of education, which aren't the kind of thing that can be bargained over. It's just wrong to bargain over those basic commitments to the assessment of merit on your part and me doing my job. So what are the basic commitments of our criminal justice system, given our Constitution? Things like citizen control. That's what the jury system is supposed to stand for. Both the grand and the trial jury in the constitutional order are they're a form of check and balance, virtually a fourth branch of government, making sure that the criminal system is behaving in ways that the citizens can approve of. That was the founders' intent. That was the design of the constitutional structure. And what plea bargaining fundamentally does is evade that system of citizen or lay control by making the doling out of criminal punishment purely a matter of official control, essentially a deal between lawyers with a stamp of approval from a judge. It treats justice itself as something that can just be bargained over. And empirically, we have really good information. This comes from John Pfaff's magisterial book, Locked In, that the root of mass incarceration is the combination of soaring crime on the one hand and a very efficient mechanism for moving people from criminal offenses to prison, namely plea bargaining on the other hand. So I think we should look at plea bargaining with great skepticism as a way of evading a constitutional system based on citizen control. And we should be committed to reviving the jury system in ways that are realistic. Now, the numbers are too big to have a jury trial for every single criminal offense, but we could certainly go some distance in that direction and away from where we are now.
The next question I have is from Dominique. Should criminal justice reform be accomplished principally through changes in procedure in the substance of criminal offenses and or in the levels of sentencing?
I think it's it's all of the above. I think the most important thing is substantive criminal law. It's writing criminal statutes in such a way that they actually describe the thing we mean to stop and no more, and then enforcing them as written, as opposed to what we have now, where we have these very capaciously written criminal statutes that are applied instrumentally by prosecutors and others. But I don't mean to minimize procedure reform. I mean, reviving juries is a form of procedure reform. And bringing sentences back into accord with the American public sense of justice is a form of sentencing reform. So I guess, Dominique, my answer is all of the above.
So in my introduction, I did mention, that you've written about California criminal justice reform. Could you tell us what exactly happened in California in particular, and what are your thoughts about it?
Yeah, it's actually an amazing story that has not been fully told before. It's remarkable. Many of us travel to California and see that things are really there just a huge amount of public disorder there. People commented on it in the media and people understand little pieces of the puzzle, but there hasn't been a synthesis to date. Well, I like to think my article is that synthesis, but I think it's the most comprehensive synthesis to date. So it's called A Criminal Law Based on Harm Alone, The Story of California Criminal Justice Reform. It appeared in the Southern California, the USC Law Review. And essentially it's this. The Supreme Court decided Brown v. Plata on prison overcrowding. And it was a classic story of judicial review. It was the court telling California that it had to release prisoners. But that seemed to trigger something in California that was far beyond anything the court could have envisioned. It started with state legislation. It continued with referenda, multiple referendums. And it continued further with mayoral and DA elections. So it quickly became a mass, highly democratic movement. And essentially what happened was California reduced many drug offenses, many property offenses, and many public order offenses from felonies to misdemeanors, and then reduced sentences for those crimes, and then released many prisoners convicted of those crimes. And that sounds simple, but it was done at a dramatic scale. So the drugs in question that were turned from felonies into misdemeanors were not just marijuana. They included cocaine, heroin, and crystal meth. I mean, California, and also in certain zones, I mean, once you make something from a felony into a misdemeanor, it's a signal to enforcement authorities that they're not supposed to take this too seriously. And in many areas and neighborhoods of California, prosecutors got the message, and police got the message. They stopped arresting for those offenses. And you saw, in effect, legalization of drugs, turning things from felonies into misdemeanors, what we call defelonization, is not literally legalization. It functions as legalization. And meanwhile, a lot of property offenses and public order offenses like loitering and sleeping on steps and so on were similarly functionally decriminalized. Until you have a whole different social contract. Oh, and by the way, people were released from prison. It wasn't just decriminalization, so fewer people coming in. People were released. I mean, literally, like the door of the prison opened. It was all retroactive. So if you were convicted of a felony drug offense, you just kind of filed a piece of paperwork. Your lawyer filed a piece of paperwork, and you were simply released. And likewise for many other small-scale offenses, sentences were shortened and people were released. So many people were released. So 55,000 people were released. 55,000 is about a third of all California prisoners at the time, a fourth of all California prisoners at the very height of mass incarceration. So we're not talking about small numbers. We're talking about massive numbers. And it changed the texture of life in California. It meant that, well, on the one hand, low-level offenders, largely non-violent offenders, were treated much more humanely than they were in the past, and had much more freedom of action. Whereas before, you know, drug addicts and people who are perennially homeless were living lives in and out of prison and constantly being bothered by police. Now they can live largely unmolested. On the other hand, it meant that many California cities fell into complete disarray, and public spaces were taken over in ways that made the city, well, fundamentally alter the relationship between individual and state. So I make the argument in the paper that the array of costs and benefits on both sides are such that it isn't clearly the case that this is wrong or right, good for human welfare or bad for it, just or unjust. This is simply a choice that democratic people can make. The California people made a choice very democratically. I imagine they will revisit it democratically as well now that they're seeing the results. And we should honor that democratic choice, even though I myself would never want to live there.
Great. I think we're going back to plea bargaining for a second because we do have a question about that. Does plea bargaining enable overcriminalization by getting rid of one of the built-in limits on criminalization? That would be in the form of logistical limits on how many people can be fully prosecuted. And that's the question.
It's a combination of plea bargaining and prosecutorial discretion and very, very broadly written substantive criminal law. But the combo is such that what you do is Congress sort of cooperates in greasing the wheels of plea bargaining. It writes these extremely, I should say Congress or state legislatures, but really especially Congress, writes these sweeping criminal statutes that make an outrageous range of things criminal, and then can trust that prosecutors will only enforce them selectively and enforce them by means of plea bargaining, so the limits of these statutes don't really get tested. It essentially is a form of legislatively enabled, unchecked executive power. I'll give you an example because that's a little abstract. One of my favorite cases to teach is Bond v. United States, a case from 2014. And it's a case about a woman named Carol Bond who found out that her husband was, that her best friend was pregnant with her husband's child. And she was very, very angry. And she put a sort of irritant powder, like an itching powder, on her ex-best friend's doorknob and mailbox. And prosecutors indicted her for using a chemical weapon in violation of the Chemical Weapons Convention Implementation Act. which is designed to prevent things like mass terrorism by means of chemical and biological weapons. And the reason they could do that is that the way the statute was worded was that it defined a chemical weapon as any chemical which through its chemical action on life processes can cause death, temporary incapacitation, or permanent harm. Well, that includes bleach, and it includes Windex, and it turns every kitchen cupboard and cleaning cabinet in America into a chemical weapons cache. But if you interpret it literally, and you say to prosecutors, hey, you don't have to prosecute everyone who does that or has that, just take your pick, then suddenly you've enabled a system of pure executive discretion. And that's a lot of what we're seeing in our criminal system.
The next question I have for you is from Ben in the audience. Has the deinstitutionalization of psychiatric hospitals since the late 20th century contributed to today's crime problems? And if so, how?
It certainly contributed to our, probably our crime problems and certainly our level of public disorder. There's actually some remarkable statistical findings on this. It appears that if you count the number of people incarcerated in jails and prisons, we have very, very high incarceration in the 2000s relative to like the 1950s and 60s. But if you count the number of beds in all institutions of control, including mental hospitals, jails, and prisons together, then the level of imprisonment or the level of carceral control, let's call it, the level of institutionalization at the height of mass incarceration in about 2007 is equal to the number of beds in the 1950s. In other words, we basically moved beds from mental hospitals to jails and prisons. In between that time, there was a period in which, like in the 1970s, when people were not particularly in mental hospitals, there had been deinstitutionalization from mental hospitals, but they weren't in prisons either. And we saw an incredible spike in American homelessness and public disorder, and indeed in American crime. And now, this goes back to the story of California criminal justice reform. We are once again seeing a situation where a certain group of people who are mentally ill, but not a danger to themselves or others in an ongoing way or a sort of florid way that would lead to them being institutionalized even under current law. People who are lightly mentally ill. If you've seen Orange is the New Black, there is a character who sort of reflects this, whose name I forget actually. Do you happen to remember, Nitin?
I can't say I do.
Okay, unfortunately, I can't remember the name of the character. Well, be that as it may, what we see again is a group of people who are, let's say, lightly mentally ill, not fully competent, but not fully incompetent either, are neither in jails or prisons, nor in mental hospitals, involuntarily committed. And they are once again sort of filling the streets with homelessness and largely low-level crime, though occasionally violent crime. So what should we think about that? I don't think we should view it as unproblematic, morally unproblematic to imprison such people. It's also not morally unproblematic to involuntarily commit them to mental institutions. I don't think, and it's also not morally unproblematic to let them spill onto the streets, which is neither good for them nor for the American public. I don't know what justice requires in a situation like this one. We may be faced with one of the permanent limits of the human condition. It's not clear what you do with people who are lightly mentally ill, disorganized, in such a way that they aren't able to live lives of full independence, but also don't justify involuntary commitment or imprisonment.
The next question I have is from Henrique. Can you further explain your views on statutory interpretation and why criminal statutes are a special case, so to say?
Yeah, I think this is, I've written about this. I wrote a piece called Textual Rules in Criminal Statutes, which came out in the University of Chicago Law Review. And basically the argument is that statutory interpretation in criminal law is distinctive in ways that make the kind of classic conservative commitment, rule-oriented textualism a bad fit, regardless of the merits and demerits of textualism in other areas of law. It's kind of like saying, well, a violin might be a great instrument, but not for playing the blues. textualism might be a great approach to statutory interpretation, but not equally in all areas of law. And there are certain problems that arise in the criminal context. So criminal legislation is, I sort of talked about this before, I touched on this before. Criminal legislation is beset by a series of political tendencies that lead it to be unusually broad and unusually instrumental. For example, it's commonly drafted by prosecutors, and it's commonly drafted in such a way as to grease the wheels of plea bargaining. There's also a lack of political pushback that leads to a bargaining process that tends to moderate legislation and catch errors in drafting. So again, think back to that case I referenced, Bond v. United States. Well, why was the chemical weapons statute written so broadly as to encompass any chemical which through its chemical action on life processes can cause harm? That outrageously broad definition of chemical weapon. Well, it's not like there's a chemical weapons lobby to push back against that breadth, right? That's not how criminal justice works. The whole design was to enable prosecutors to get plea deals easily. And that's a really common phenomenon. It's amazing to scan through federal penal statutes and just count the number of any's. You know, whoever falsifies any record or document with intent to impede any matter under the investigation of any branch of the federal government, any, that's reckless drafting. And that presents a really difficult question if you think a judge should be a faithful agent effectuating the democratic will. Well, what do you do when the statute doesn't actually name what it wants to see stopped, when the statute itself is written for instrumental purposes? Do you read it on its terms and thereby allow unbridled executive and unreasonable executive power, enforce them purely as written? So I'm trying to question a piece of the conservative orthodoxy, the idea that textualism for all things at all times. I think we need another approach to the criminal context.
Another question from Dominique is, are there any areas of the law that you think are under-criminalized?
Wow, I've never been asked that before. Dominique, I gotta say, a tentative yes. There are probably some areas of law that need to be more criminalized, but I can't think of them at the moment. We really have a lot of criminal law. We have a lot of criminal law in the white collar context as well as other contexts. And I could not at the moment think about where we need much more of it.
So a question that
Nitin, I wonder if given the time, we should pivot to some of the fun stuff like how to have fun in law school, what to study, things of that nature. What do you think? You're the leader here, but I just want to flag it for you because I think time is drawing to a close.
Sure, we can go ahead and do that. What are a few things that you wish you had known when you started law school about how to get the most out of law school?
That's a great question. Okay, two things. You know how when you go to law school, you learn IRAC, issue, rule, application, conclusion?
Right.
It's the A that matters. Application of law to fact. That's where all the action is. That's where the real demonstration of understanding, the real lawyerly skill and competence gets displayed. There's a tendency for students and young lawyers to think the actions in stating the rule, you've got to have a really good rule statement. But once you get out there and practice for a few years, you realize that everyone knows the rules, and that's unremarkable. The real legal skill, the thing you see in the great judges, the great lawyers of the country, is the ability to apply law to facts in ways that show a nuanced understanding of what the law is for and why it functions the way it does. The other thing I wish I had known back then is, I guess I sort of developed it in law school. Basically, what happened to me in law school is I was taught a certain way of briefing cases that was very time consuming and didn't seem to me that it really taught me the essence of the case. And I observed that on exams, a case stands for exactly one proposition. So I developed this thing that I called to myself, I named it for myself the one perfect sentence technique. I would read a case for class and I would work really hard to craft one perfect sentence that captures the essence of the case. What does this case mean? And it would be a sentence that blends some law, some fact, some context. It would be a single sentence that says, you know, um, uh, violence against women falls outside the domain of the Commerce Clause because such violence is a traditional state concern and is neither in any direct sense is neither in any direct sense interstate nor commerce, right? And that would be my effort to, obviously that's Morrison. That would be my effort to summarize the case in a cogent way. And I just write it on top of around the heading of the case. I jot it in my case book or type it in my virtual case book. And I found that it gave me the ability to synthesize what cases mean and draw on them immediately in memory in ways that were extremely helpful for my not just my law school career and my grades, but for my overall understanding of how the law works. So Iraq is about the A, and one perfect sentences are helpful.
That's very helpful advice. Since this is a study break, I think it's appropriate to end on, this question, but what did you do in law school to relax and unwind when you weren't, busy, with the books?
Well, there was a lot of hanging out with friends, and I really treasure my friendships from law school. They stay with me. I still, just this past winter break, I rented boats with one of my friends from law school, and we boated around the Gulf of Mexico, and which was really fun. Houseboats. It's like a motorhome on the water. And I got together with another group of friends, also from law school, for just a weekend of hanging out and talking and drinking and having fun. So those friendships meant a lot to me and still mean a lot to me. The other thing I found was that law school was such a frantically political environment. It was so ideological. It was so heavy in its aggressive political, even back then, political polarization and tribalism were at a very high pitch, not as high as now, but very high. And it was emotionally taxing. And I found I needed an antidote. And I started to get really into stand-up comedy, particularly stand-up comedy about politics, just as a sort of a way of poking fun at the humorless, plotting partisanship of the law school environment. I thought that was helpful. Law school students characteristically have a lot of things going for them. They're very energetic, they're very smart, they're very analytically shrewd, and they are ready to uphold they care about politics. They care about matters of the common good and justice so far as they can see it. But they don't tend to be, they take themselves pretty seriously. They lack a sense of humor. Like and I say this about myself too. So what are our flaws? And the stand-up comedy was for me a sort of antidote to the character flaws both I and my peers brought to the table.
I think that concludes kind of tonight's study break then.
Thank you. That goes quick.
Half an hour does go by fast. Thank you very much, Professor, for joining us tonight. We really appreciate your answers to all of our questions.
Well, that was great. It's strange because I know I'm talking to, I don't know, dozens of people, scores of people, maybe hundreds of people. I have no idea how many of you are out there, and I can't see anyone. But I hope this was a good session, and I wish you all the best. Hey, I want to say something about that. I think this is a pretty tough time for FEDSOC students. It was bad when I was in school. It's worse now. There is so much bullying. There is so much exclusion and ostracism and condemnation, and it's a very, very heavy cross to bear. Don't lose hope. It's like one of those commercials, it gets better. It really does get better. But not only that, I think as hard as things are now in these elite university institutions, I think there's a lot of hope unfolding in the broader politics of the country. And so don't lose hope and keep your head up.
That's excellent advice, Professor. Thank you very much again for your time. Thank you to everyone who helped organize this. Thank you to everyone in the audience for attending. We hope that you come back next week for next week's edition of the study break. Have a good evening, everyone.
Bye.